Hello, and welcome back to Coin Lady channel. I imagine it's really challenging up here. Following the SEC vs Ripple decision by Judge Annalisa Torres, well, Kim Jong-ginza. With the verdict in hand, he might as well have been dead. And now he's doing interviews on national TV, so I must have been imagining it. I'm sure he's terrified at the prospect of answering questions on the SEC's largest crypto setback to date, the SEC Ripple case, in which XRP was determined not to be a security. He was featured on Bloomberg not more than a week ago. The whole thing took maybe 10 minutes. For the next 10 minutes, he avoided answering any questions, gave vague answers, and refused to admit defeat. Not enjoyable, I assume. This makes me very happy. Also, this headline from CoinDesk makes me very happy. CoinDesk, SEC case had almost no impact on Ripple's talks with central banks, says exec. Another slap in the face for the SEC, according to attorney Bill Morgan. Because it turns out that the entire 2.5 years of crap were totally pointless. Said what you will about CBDCs, it hardly altered the end result of XRP's positioning as a bridge currency for central bank digital currencies around the world. Personally, I find them to be really frightening. Although I find them to be somewhat frightening, I am aware of the fact that they will inevitably occur. What this means for the future of digital currency adoption at my country's central bank is a mystery to me. The inevitable, however, are not just coming to a wider scale as time goes on, but they are now here. But before we go any further, let me say that I have zero experience in the financial sector. I'm not giving investment advice, therefore you shouldn't purchase or sell based on what I say, right? I'm just a fan who occasionally posts videos to YouTube regarding crypto-related things for kicks. Okay, so let's go into this first bit of crypto fundamentals. Gary Gensler won't say if the SEC plans to appeal the Ripple's win. Yes. This includes protection against him simply not responding to inquiries. However, he believes he must do so since the consequences of not doing so would be more severe. That's why he's making himself go on national television and look like a total idiot. And I mean, I just adore it. I think it's great. SEC Chairman Gary Gensler has decided not to reveal the next step that the regulatory agencies will take in the Ripple case. Yesterday, Gensler was interviewed by Bloomberg's Kaylee Ling, who asked him about the SEC's potential appeal of the judge's order, in particular with respect to the ruling on Ripple's programmatic selling and false claims. Of course, the only aspect of Judge Torres's ruling that is relevant is that pertaining to programmatic sales. By pointing out that XRP lacks the characteristics of a security as outlined in the Howey test, the court ruled that XRP is not a security. After hearing this week that the SEC is dissatisfied with the verdict on retail investors, the reporter felt compelled to ask the question. The whole purpose of the damn case hinged on the fact that you were a little bit of a punk, so you better be. I know. Many claims and accusations have been made, but the central question remains, what the hell is XRP? Does its very existence indicate that it is a security? The correct response is no. So course, you should be sad since you're the last of the idiots. These persist. The SEC has indicated in a motion it has filed in the Terraform Labs case that it is contemplating a number of different avenues by which to seek review. So the journalist followed up with another question to Zoller, this time asking if the SEC planned to appeal the judge's decision. According to the judgment in the Ripple case, XRP is only a security when offered to institutional investors, and she is quoting this. That's not the case with average people. You've already expressed your dissatisfaction with the decision. The SEC has already stated its intention to seek further review. Does this indicate you will be appealing, and if so, what are your arguments against the ruling? I don't think this report is attempting to do what the Bitcoin Max report is doing, where it's so unclear what a poor ruling, sometimes it's a security, sometimes it's not. My brain exploded, don't make sense now and then, but we'll forgive you anyhow. I'm going to assume that this interviewer just missed that but still asking if you're going to appeal, and there is no firm answer here because while XRP was ruled to never be a security, it can be packaged and sold as a security, and the Bitcoin maximalists and the haters like to pretend like that nuance doesn't exist, but it does in this case. Without legally confirming it, his team made it quite plain that they intended to make the allegation at the time they did. Wait a second. And I just talked about that on the channel a few days ago. This is a very direct question being asked of him. So, the status quo remains unchanged. In response, Gensler explained that, as one of 5 commissioners, he was waiting for the commission to make up its mind before taking any further action. Therefore, he cannot decide whether or not the SEC will appeal the decision. That's exactly right. But let's face facts. You won the popular vote, you're the one. 2 more Republicans and 2 more Democrats round up the group. The voters have spoken. Here, though, is Kim Jong-un's own words. I'm just one of 5 commissioners, so far, we haven't decided whether or not to appeal. We will discuss the staff's suggestion and maybe take it to the next level for consideration. I don't have any other quotations relating to that. That's quite a departure from what the SEC was reportedly claiming in the DOE Kwon vs. Terra Incorporated litigation, where it was claimed, and I'm quoting here, that the SEC intended to recommend review to the SEC. That's why it's going to give itself a glowing review. Simply said, the sentence sounds ridiculous. But what Kim Jong-un is claiming here is very different. Is he trying to take some of the steam out of this? What follows is attorney John Deaton's commentary on this interview. Gary Gensler is either completely ignorant or deliberately trying to fool everyone. These tokens are not considered securities under federal law. The offer and sale of the tokens may be subject to securities regulations, just like the selling of Bitcoin in SEC v. Shavers, 2013, and the sale of other assets such as real estate, liquor, citrus orchards, chinchillas, and even beavers. Stop arguing that these tokens are more like stocks since they have no inherent value and are used for speculative purposes. This is one of the things that really grinds my gears, and it's not even a part of the Howey test, Solicitor Deaton went on. As he continues, he realizes this. However, how often have you heard over the years, on national television, and in actual legal papers from the SEC, that speculation and the intrinsic worth of additional has nothing to do with whether or not it is or is not a security, or whether or not it is packaged as a security? Nothing. All they do is talk. In any case, as Deacon elaborates, the Howey judgment made it quite apparent that the only thing that matters is whether the contract, transaction, or plan involving the sale of the asset passes the Howey test. Whether or not the seller is engaging in speculation or whether or not the underlying asset has intrinsic worth is irrelevant. The Supreme Court has ruled. Gary Gensler must finally quit defying authority. Exactly. Because Gary Gensler and the rest of the SEC jerks disregarded the law, they lost the case's most important component. And they failed miserably in the one department that actually counts. Fantastic. Another smack to the SEC's face, courtesy of attorney Bill Morgan. One thing is certain, the rest of the world couldn't give a hoot about the United States enforcement efforts if they tried. Hence, the necessity of this paper. From the looks of the coin desk, he was referring to this. The ripple effect of the SEC case was minimal. If you're worried about the viability of XRP as a bridge currency or the viability of Ripple's business model, you need go no farther than the United States, as evidenced by recent discussions with central banks. In other words, any quarter in which the United States is involved in the on-demand liquidity market is totally disastrous. And then, as far as I can tell and what ripples are taking in here, the lawsuit caused absolutely no damage whatsoever to XRP's positioning as a bridge currency, because the rest of the world doesn't give a damn about this. In any case, the lengthy legal battle with the U.S. Securities and Exchange Commission had virtually little effect, as evidenced by the ripples of peace that followed. On Friday, the company's vice president of central bank engagements discussed the company's discussions with central banks with CoinDesk TV. James Wallace added that the ruling that XRP sales by Ripple did not amount to investment contracts was a huge win for the industry as a whole and for Ripple specifically. Ripple's ability to initiate dialogues and initiatives with central banks was unaffected by the court battle, which had been going on since 2020. And now, for a Wallace quotation. "So far, we haven't heard 'we don't want to talk to you because of it' in quote, Z from any country. So, Ripple, what do you know? The rest of the world doesn't give a damn, and they haven't given a damn about this, I'm telling you. It's sad that the crypto market's price movement is so dependent and tied to developments in the United States in general. Because, let's be honest, it's obvious that the current state of the stock market is reflected in the declining price of XRP. That settles it, then. Adoption regulations come next. As a result, there are unfavorable outcomes and missed opportunities. For the past 2.5 years, I've discussed them at length elsewhere in relation to XRP price movement and certain aspects of adoption, but not here. Nobody gives a hoot about it outside the United States. I just wanted to say that it's great to see that XRP has been chosen as the greatest cryptocurrency in the world to serve as a bridge currency. In fact, it's the only option that's seen widespread adoption for that purpose. Stablecoins is one possible interpretation. However, there is no alternative decentralized cryptocurrency, regardless of location. Also, digital currencies pegged to a certain fiat currency. Risk of default by the other party is present. Furthermore, not all parts of the world will be amenable to doing so. Therefore, if you're talking about something outside of any particular jurisdiction, you'll find that just one has been seriously adopted. Also, XRP. First mover's advantage, if you will, in that particular application. My friends, I do not believe that ship is leaving port. Since I'm not a certified financial planner, you shouldn't use my advice to make any investments or trades. Please like and subscribe my channel. See you later, bye.